Welcome back to Courtroom Chronicles, where today's hearing unfolds like a legal thriller. We're diving into one of the most intense moments you'll ever see inside a courtroom, a clash between the bench and defense attorney Brian Steele that leaves everyone stunned. In this heated exchange, the judge demands to know how confidential information was obtained, information that was never meant to be heard outside chambers. But what starts as a procedural question quickly escalates into a high-stakes standoff about ethics, privilege, and professional conduct. You'll hear accusations of eavesdropping, talk of mistrial motions, and even a threat of contempt of court, all playing out in real time.
You could have gotten him. So I'm going to ask you again. And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6. I know what the rule says, but here's the thing. Well, let me just. You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah, and that's why I raise it. It is that serious that we...
Okay, pause right there. What you're witnessing is a direct conflict between legal ethics and judicial authority. The judge is demanding to know how Attorney Steele got access to privileged information. But here's the kicker. Rule 1.6 of Georgia's Rules of Professional Conduct makes it illegal for an attorney to reveal confidential client details, even if ordered. So, Steele's caught in a legal vice: obey the judge and risk violating ethics, or refuse and face contempt of court. Talk about a lose-lose situation.
How did you get this information? I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law. You cannot you can't violate something and then use privilege, okay? I'm not violating anything. Okay, but that's why I'm saying, how did you get the information? But just listen to what I'm trying to tell you. You're saying, you're threatening me with contempt. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't. Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule. All right, well, I'm gonna hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it. You can't do that. Yes, you can, because I have an idea how you got it. Well, your idea. I have an idea how you got it, but that's improper, sir. Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence. I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time. Judge, listen, and listen, I'll do whatever you want.
Notice what Steele is doing here. He's quoting comment 5 of Rule 1.6 word for word. That's not arrogance, that's legal armor. He's trying to build a record that he's acting under ethical compulsion, not defiance. But from the judge's point of view, this looks like obstruction. And in court, perception can be as powerful as precedent.
Tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So, but you're assuming something because I told you already. Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, There's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But
about?
anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness.
And there it is, the C word no attorney ever wants to hear, contempt. The judge gives Steele a deadline to reconsider. This is where courtroom drama turns psychological. Both men are asserting authority, neither willing to blink first. Imagine being in that room, tension thick, silence heavy, both sides knowing one wrong word could end a career or derail a case.
That's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside our presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information.
This moment right here. It's huge. The judge just speculated every possible way the defense could have received the information, even suggesting that someone from Chambers might have leaked it. That's not just procedural, that's an accusation. Think about it, if this leak did come from inside, we're no longer talking about courtroom etiquette, we're talking about a breach that could trigger an internal investigation.
That needs to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right under the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
the Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert.
Now Steele fires back, calling for a mistrial, arguing that the judge's private conversation with a witness, outside defense presence, is a material part of the case. He's essentially saying, "Judge, your actions compromised this trial." That's bold. In most courtrooms, that's the kind of statement that can cost you your standing, or your freedom.
Did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not.
The prosecution steps in to restore order, or at least to control the narrative. Listen closely, they're emphasizing that the ex parte meeting, a private discussion with the judge, was legal and properly recorded. But here's the subtle twist, they admit something did leak, and that's what's making the entire courtroom spiral. So the big question, who talked?
We are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields.
This is a key turning point. The state argues that Rule 1.6 doesn't protect what Steele is refusing to disclose because the information didn't come from his client, it came from the court. If that's true, then Steele isn't shielding his client, he's obstructing a judicial inquiry. And that, folks, could turn ethical defense into criminal contempt in a heartbeat.
To his client, from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held.
Another defense attorney jumps in, and now the walls are closing in. Attorney Sharp confirms that the defense was left completely in the dark about a meeting between the judge, prosecutors, and a sworn witness. Sharp's argument: this was a critical stage of the trial, meaning the defendants had a constitutional right to be present. If proven true, this isn't just bad optics, it's structural error, grounds for an immediate mistrial.
That leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, sir.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up.
The defense is drawing a line in the sand. They're not just protesting fairness, they're questioning the legitimacy of the entire trial. But look at how calm the judge remains when denying each motion. That calmness? That's experience, but also control. The message is clear: we're moving forward, whether you like it or not.
Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is, just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to.
And there it is, the boiling point. The judge officially orders Attorney Steele into custody. This is the moment every lawyer dreads, when courtroom debate turns into handcuffs. Think about the optics, a defense attorney being arrested in open court, during a live proceeding, for standing his ethical ground. It's rare. It's dramatic. And it's the kind of moment that sparks national debate about the balance between judicial power and legal ethics.
Accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in, and we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Huey.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time, and when the court did come out, we were not made aware that there had.
The judge's tone here says it all. He sees this as a direct violation of the sanctity of chambers, a sacred space in court procedure. To him, Steele's refusal isn't bravery, it's defiance that undermines the justice system. And yet, to many watching, Steele's stance looks like moral courage, an attorney risking punishment to uphold his duty. Which side are you on? Was the judge right to press, or was Steele right to protect confidentiality? Drop your thoughts below. This debate is far from over.
Some noticed that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for a mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means that we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not calling nothing.
I'm not going to participate in the trial without the Steele and without
You don't have that luxury at this point in time, sir. You don't. You don't.
without the court addressing.
You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot. And
Sir,
technically, I
you have
feel as though I can properly represent Mr. Williams
well,
until this issue is
you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning. That
if there is any accuracy to some of the information that we don't.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you've made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
And that's where today's courtroom saga leaves us, a trial shaken by questions of ethics, privilege, and power. We saw a defense attorney held in contempt for refusing to reveal his source, a judge determined to defend the integrity of his chambers, and a prosecution desperate to contain a leak that's now front-page news. This case forces us to ask, when does protecting justice cross the line into defying it? If you found this breakdown as intense as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns right here on Courtroom Chronicles. Until next time, stay sharp, stay informed, and remember, in court, truth isn't just told, it's fought for.